Thank you. Hey, everybody. Thanks for being there. Judy, the YouTube lawyer, here with our distinguished guest, law professor Joe Potuto, and Tallahassee attorney Katie Bogenschutz. Thank you for being here, you guys.
Thanks for having us.
So who wants to start out giving some commentary? I guess Joe probably already has her commentary because she was discussing it live this morning.
Yeah, I'd be happy to start. I thought the hearing today went as expected. I guess I would say the one thing that we don't know is they must have had some discussion of a motion that we didn't hear. And the defense said it could, their case could be 4 days or 6 days, depending how the judge is going to rule on that motion. And we don't know what the motion is. The only guess we might have is that the defense had a motion with regard to the 2 informers that the state wanted to use, and that one didn't get mentioned on the record at all. There was no mention as to whether it was denied, whether the judge agreed with the defense. So, you know, that leads one to think that maybe that's what was going on, but otherwise it's a mystery, and that would be the big thing because everything else that happened was pretty predictable. I don't think there was anything the judge did that was any kind of a surprise. The only other maybe news that we got, and I say maybe about it, is that the defense said a couple of times that they're putting Donna on the stand. We all thought that was going to happen, and of course the defense could say it and not do it, but it appears that they are letting us know they're going to. And then they mentioned that Charlie might testify, which I don't believe, but they said, but the defense said that a couple of times also. So those are my sort of quick notes on what struck me about the hearing today.
Well, I listened while I was driving, so I can't tell you that I was looking at faces or, you know, physical reactions, but I did skip back and forth a couple of times because the audio was a little bit iffy, just to make sure I caught everything. And I thought that the one motion that I would love to read these depots, you know, the messy, you know, the messy petty part of me would really love to read these depots where apparently the defense was asking the investigators how they personally felt about them, like whether they were ethical or what they had done in this case. And I'm just like, oh my God, those are probably amazing.
And then they moved not to let the prosecutor use it. I guess
but I mean, it wasn't going to come in. I'm shocked that they even asked.
I know. Well, I guess the other thing I would say is Georgia got testy at one point, and it was related to the number of papers and arguments that are being made that she thought were unnecessary. And there I absolutely agree with her. And Judge Everett came into the hearing not smiling, not jolly, very stern. And he didn't loosen up until we were well into the hearing. And again, I have no reason, I have no way to know, but I also attributed it to whatever happened because they were late coming out and Judge Everett is never late. So I attributed that also to whatever happened before he came out on the bench. But, you know, that's the part of this entire hearing that we don't know what happened. So it's frustrating.
And he was a good 12 to 15 minutes late, right?
What?
Yeah.
He was about 12 to 15 minutes late.
Yes. And he never is late. Yeah.
But I did see on Deep Dive True Crime, before Everett showed up, there was some footage of Donna and her attorneys just laughing and looking really animated and happy. So it was bizarre. I've never seen anyone look so jovial before their pretrial hearing in a murder case. So, and also, Mentor Lawyer Deep Dive True Crime, he did a new video just a few hours ago, and I think he said that motion we didn't get to see or hear did have to do with that so-called new investigation with Donna potentially trying to bribe a witness or witnesses. And from what I recall, maybe the judge reserved ruling on it, so he didn't make a decision yet. But I could be wrong because I didn't take
Judy, he
notes.
clearly didn't make a decision on it, because if he had, that would have been part of the record of the hearing. And I'm virtually certain he will make a decision before the trial, because both sides will want to know whether they're going to be able to refer to it in opening statements. So, and I don't think he's going to get any more information. I think he'll probably review some more, review the motion again and any other arguments that were made about it. I mean, they made some arguments at an earlier hearing. But yeah, I mean, that was my guess, because it was the one motion that should have been heard today that wasn't heard today, and there was no reference to it whatsoever. So it did appear that it had to be that motion. And I guess we'll know when the trial happens exactly what's going on. Yeah.
Yeah. Well, Katie, I have a question.
Sorry, go ahead.
Oh, sorry. Katie, I have a question for you, because if they're still acting like Charlie might testify for Donna, then wouldn't we already see some sort of order for transport by now? Because I didn't see one.
I would expect so. However, because he's so high profile and because he was moved because of security issues, I don't want to speculate as to what they might do to try to, keep him lower profile in the jail, and then also potentially to even house him separately, because the Leon County Jail is not huge. And you're going to have Luis that's transported in. There's no way you want him housed anywhere near Charlie. And you end up like in a larger jail system, you put in keep separate orders where you list the people who should not be kept together, and the jail will do that themselves. Research to see who's co-defendants and who has beefs against each other, who's flipped on each other, and just to try to keep the peace in the jail. It would not shock me to find out that Charlie was kept in one of our like kind of ancillary jails, like maybe in Monticello, or which is one county to the east. Sorry, it took me a second. Or Gadsden or something like that, just to try to tamp things down a little bit.
Yeah, that makes total sense. It seems like in this trial, a lot of things have kind of been kept secret, for some reason or the other. And security is a huge reason. Yeah.
Well, I mean, especially where he's gotten death threats and stuff like that. And you don't know what the affiliations of other people are in the jail, but like Jefferson County is super rural. I can guarantee you there's no member of the Latin Kings in the Jefferson County Jail.
Oh, okay. Okay, you got a question. Katie, you're a criminal defense attorney. Would you ever put Donna Adelson on the witness stand? That is insane. I can think of no upside. What do you think?
There is no upside, but it's going to be her decision. The other thing is that somebody has to explain some of these statements that she made. This TV is 5 is one of the worst things that she said on one of those calls, with the TV being code, and then Charlie says it's not code for anything, and it's a hot mess. Somebody's going to need to try to explain it. Charlie actually thought he did fairly well. Clearly, the jury didn't buy it, but based on the contents of his jail calls, which I found really hilarious.
The comment about the TV is 5 interests me in a slightly different but related way, because Charlie also said, I wish he had used a different word, which rang to me as it was code, but you shouldn't have used the code we've used before. Find a different code to use. And I haven't heard anybody, I don't think Georgia went after him on that point, but it does seem to me that you can infer from that statement that it was code. He just wished she had used some other code word for what was going on.
Exactly. He totally tripped up there. So,
and there's a lot of people that kind of went after Georgia for not going after him more aggressively on the stand. I wasn't in the courtroom. I think the acoustics in there are terrible. I prefer to watch online. But like, you get a really good feel from a jury as to like where we're going with this, as you're like interacting with them with body language in the courtroom. And I get the feeling that she was just like, all right, they're done.
Yeah.
Well, and she used it. I mean, one tactic that prosecutors use, it's very effective, is she got out the things she wanted and then wove the tail and closing argument. Pushing him might have given him the opportunity to say something that might have persuaded or at least rung true with the jury. She didn't push him, so he didn't get a chance to make any of those arguments if he had them. And then she was able to just build her argument in closing in, I thought, a masterful way.
Yeah. Yeah, it's very difficult to, I mean, it's easy to cross-examine a single eyewitness. And I know other shows have talked about this, like, you know, his vision was bad. He had a motive to lie. He's crazy. He's schizophrenic. He was off his meds, whatever. But to cross-examine each little circumstance that you build up upon each other, and any single one of those could fail and all the rest of them remain. So as opposed to an eyewitness. So circumstantial cases can actually be some of the strongest cases that you have as a prosecutor.
Right. Okay. So I think people have asked this before, but what do you guys think is the biggest piece of evidence that will convict Donna? Who wants to go first?
I'll defer to Joe because I have to collect my thoughts.
Okay,
There's a
Joe,
lot.
Professor Joe.
You know, this question's a little difficult because the circumstantial case has a lot of different components to it. And so, I mean, there are 2 or 3 different things that strike me as really compelling evidence. One is obviously the flight, but the flight doesn't go to the elements of the crime. It goes to her, you know, consciousness of guilt. The other one that I guess I would point to is her reaction at the bump. I mean, apparently from the argument they were making today about the defense, this is about wanting to refer to the Latin kings and to refer to Luis Rivera as a leader of the Latin kings, is because they want to show that it explains her reaction and how frightened and nervous she was. But she wasn't the least bit frightened or nervous. She was cool as a cucumber at the bump. There was not the slightest betrayal of anything. And so, I mean, I think her reaction there was so unlike the way you might expect anybody accosted on the street by a complete stranger and then essentially threatened, you've got to pay me off. And if you didn't know what somebody came up to you and made those claims and you didn't know what that person was talking about, you wouldn't stand there and have a conversation. You'd get away as soon as you could and report it to somebody.
Mm-hmm.
And you certainly wouldn't call him.
No, that's right.
Yeah, without going
Okay,
to the police first.
Yeah, let's review. What was that you
Right,
were
and
asking
your
me to
first
do?
reaction wouldn't be to call your son and say it concerns us. I mean, so I think that's
Maybe
pretty
calling
compelling
Peter
evidence
Weinstein, the
also.
chief judge of Broward County, trying to get a security detail around your condo while the homicide squad or whoever their best guys are respond to your high rise as a
Right.
special favor.
Yeah. And during that time, Wendy was clerking, or she was working for that federal judge, Diaz, also. So they had all these connections surrounded by people with power and money, but yet she never contacted the police about that. So I was going to say
Keep in
the
mind-
bump and her phone calls also as the biggest piece of evidence. Yeah.
Especially
Katie,
if you
you didn't
leave
get
in the
a chance
fact
to
that
answer.
there's, yeah, well, especially if you leave in the history of this family and the, you know, the power that they have access to, the people they have access to. I mean, like, if this had, so the bump actually happened when I was a prosecutor in South Florida, that like Michael Weinstein could have called me and said, hey, can you get your friends down at SID to help out with this? And we would have made a couple of phone calls and they would have gone out to the house. Like it would have been, you know, and it would have been, you know, the thing would have been greased. It would have gone through the proper channels, but it would have gone significantly faster because it wouldn't have been even an intake. It would have just been like, hey, this sounds bad. Who can take this?
So did you have connections with Michael Weinstein?
Oh, I've tried cases against Michael Weinstein.
Oh, okay.
I've known him
So
for years.
that's he's the son, or is he the judge?
Oh,
isn't
Michael is the
Peter
son.
judge?
Yeah, Michael's the son who he's about Charlie's age, I think.
Yeah,
I
he's
don't know if
friends
they were
with
the same year
Charlie.
in school. Peter is the father. Peter used to be the chief judge in Broward County. I've had hearings in front of Peter. Nice guy, you know. But I just, you know, like, Michael's a former prosecutor. He knows plenty of people who are prosecutors. He knows plenty of people who are U.S. attorneys. Peter Weinstein could have called somebody over at the sheriff's office to get their wiretap team on it. Like, I mean, there's a lot of resources that are down there that you don't have in some of these smaller agencies, because think about it, you got the port, you got Miami. I mean, a lot of the law enforcement down there is cross-sworn with the feds because of DEA and, you know, interdiction squads and stuff like that. So, I mean, like, it's easy, and there's tons of resources. Like, I that's the thing that blows my mind, that they never tried to do a single thing when they had access to all these people.
Mm-hmm. Yeah, so true. Yeah. There's a question here from Rosemary. Could Donna change her mind at the trial to testify? Sure she could, right? They don't have to decide until later.
They don't have to decide until the moment that they're either going to rest or put her on the stand. I'm not suggesting they'll put her on last, although that, I guess that might be, I might be inclined to think that's what they would do. But they don't have to decide until the very last moment. They don't have to give notice to anybody.
And you'll also see that even if you'll see defense attorneys occasionally in cases like, I think about the Murdoch case, if anybody watched that, where it seemed like he and his attorney started having a fight towards the end of the trial. And one of them said, oh, he says he doesn't want to speak to me, and that's hurt my feelings. But you could tell that, like, nothing was going to keep Alec Murdoch off the stand, even if his lawyers were telling him to STFU. So there's a colloquy that every judge goes through. They put the defendant under oath. They make sure that this is their decision. Your attorney can advise you. They can give you ideas. They can, role play with you, even to try to play cross. But it's your decision at the end of the day. But you break it, you bought it.
Yes. And Joe, what's your opinion on Donna testifying? Do you think that's a good idea or necessary?
I don't think it's a good idea, but I do think it's necessary. I mean, I don't think you would put a defendant on the stand unless most defendants anyway, there might be an outlier somewhere. Unless you absolutely had to have that person on the stand. And I think Katie's exactly right. I don't see how some of the evidence that has to be explained will get in unless she testifies. Even Charlie, if he testifies, is not going to be able to cover everything that she would need to try to explain. I mean, he could come closer than anybody else I could think of, but even he won't get them the whole way. But she's going to be, I mean, there's so much she said and so much she wrote and so much she emailed and so much odd behavior that she's going to have to explain. So, yeah, no, you wouldn't put her on if you could avoid it. But I do also think that Katie is right. She's going to want to testify for reasons that escape me looking at the case. She, I think, from what we can tell, thinks that she's going to be acquitted. I mean, there's stories that she's been writing people or talking to people outside saying, I'm going to be acquitted. Now, that might be her just trying to sort of grease the wheels and pretend, but I'm inclined to think she really does believe it. Her behavior today, smiling and everything, would lead you to believe she really thinks that she's going to be able to persuade the jury. Charlie certainly did. He thought he did. I mean, Katie's right. But not only did he think he did a great job, but from all reports, so did Daniel Rashbaum. I think he did a great job following the script that they laid out, but there was a failure of good judgment in thinking that script was going to work.
I will say it again. I think that script may have worked in South Florida.
Really? I can't
Yes.
believe it.
We had, so up here in Tallahassee, we've got a city full of government workers, rule followers, university type people, students. It's the most educated city in the state of Florida. And down south, it's not rule followers and not in that category. And there's a lot of people who are maybe foreign born who don't trust the police, who don't trust law enforcement, and for good reason. So, look at the Nicholas Cruz case. Like if the death penalty was not meant for someone like him, then we shouldn't have it. And a Broward jury said no. So Broward County, Dade County, you get crazy verdicts out of there. I say that as somebody, I lost a trafficking and heroin case where it was in his butt. And then the jurors stopped me outside the courtroom and asked me if I wanted to go to Applebee's with them. And I was just like, I told the foreman, go have dinner with your 5 crazy friends. No. But it's just, there's some real skepticism of law enforcement down there. And I don't think that you have the same skepticism up here. And I've also seen a little bit, and I'm probably going to get a bunch of text messages after this, a little bit higher quality of police work up here too.
But what about a skepticism of the police would lead a juror in Miami to accept a story from someone who says, I was blackmailed, compared to the reaction he had when the $5,000, he wasn't going to pay it, but the reaction to the big blackmail, he just sort of opens the safe and hands the money over. I mean, I don't see law enforcement has nothing to do with it, and that one just defies any common sense.
Yeah, and I'm not saying it makes sense. I'm just saying that there are juries in South Florida, and just the composition of the population down there is, it's almost like you're primed to be very skeptical of what the government is putting in front of you. And it has to do with, and for good reason, like there's a large Haitian population, and people from Haiti obviously do not trust the police, and for good reason, right? There's people who are Cuban and, have some real issues with the government down there and maybe fled that government. So, there's, it's a different population. And frankly, there's quite a bit more public corruption down there too. Like there's more access to money, and therefore there's more, I don't know, more temptation, I want to say, down there than I think that there is in Tallahassee. It's like when I moved up here, it was like moving to Mayberry. Everybody was nice.
You're I don't know where you're going to be able to go eat dinner in the next month. You're sort of, everything you're saying is hitting some group or another.
I'm just saying it's such a difference in the populations that I'm not saying it would have worked in South Florida. I'm saying I think they would have been out a heck of a lot longer. I think that there may have been 1 or 2 holdouts that really, sunk their claws in. And just based on the experience I had with juries.
It's an interesting take, because Charlie and Donna believed they wanted a Miami jury because Miami juries were savvy and people in Tallahassee were hicks. And your take, given your experience working there and in Tallahassee, is exactly the reverse. In Tallahassee, they were going to get the intelligent jury. So if you're correct, they got the jury they wanted. And what they miscalculated was that an intelligent person would believe a word they said.
Right. It's there's skepticism, intellectual skepticism, and then there's like just sitting down and putting it all together and saying, no. I was shocked at some of the verdicts that we got in South Florida. It wasn't for any lack of lawyering. Sex cases with full confessions, I saw acquittals on. It was shocking. And it's just no better example than the Cruz case, where death penalty was made for this guy. I'm sorry for those of you who don't agree with it, but if you're going to use it, sounds like it ought to be used on him. And the fact that there were holdouts, shocking.
Yeah. Okay. Well, this is an interesting question. Let's play devil's advocate. Is there any evidence that can persuade the jury to acquit?
Silence.
Let's think. Let's think real hard. Well, because Luis Rivera didn't actually mention Donna, he mentioned Wendy, and he knew about the dentist.
And the
it's-
lady, which I think was Wendy.
Yeah,
Yeah, it could be
Yeah.
argued the lady is Wendy.
I guess my answer would be, I don't know that there's any evidence that would persuade the jury to acquit. But I think, at least in theory, if she can portray herself and convince the jury of it, that she went along with what Charlie needed and wanted and believed him, didn't have any reason to think he was involved. I mean, she could persuade them of that with her testimony, and I don't know what other evidence she'd use, because I think the actual evidence undercuts her being able to say that. But that's, I think, her best path to an acquittal.
Yeah, she's got to embrace some of the evidence and say, you know, maybe my son did do this. I don't want to believe that as his mother. You know, I don't want to believe I could have raised someone like that. But, you know, at the end of the day, maybe he did. And if I assisted in helping him out after the murder,
Right.
that's not a crime, because she's an immediate family member. And you cannot be an accessory after the fact as an immediate family member. Now, I began looking up to see if a spouse counted, or if, you know, like how far do you go? Because it turns out cousins don't count, but it does look like siblings count and parents and children count.
Right. But of course, if that's her defense, and, you know, I may not be creative enough because I don't see any other defense there. She almost has to implicate Charlie in one way or another, which is, you know, what I don't believe she wants to do. So it's hard to see how they're going to wend their way through, if that's the defense, without really underscoring Charlie's culpability. So it'll be interesting I don't think she can do it. I mean, I think she may hold up on direct. I don't think she's going to hold up on cross. I just don't see that she can keep her story straight. I think she will have a hard time not sounding too assured or arrogant as she's making her case. I think she will get prickly if Georgia pushes too much. Now they're going to try to, you know, work with her not to do any of those things, but, you know, it's hard sometimes. They say leopards can't change their spots, and, you know, that's what I just can't imagine she's going to be able to do it. She may surprise me, and then I will be very impressed, but I just can't see it.
Yeah.
Have either one of you ever had to testify, like under oath
I
in
have.
court?
Yeah.
How many
Yeah.
times?
Mhm.
A couple times?
Just once.
I've done it twice, and both times I was beside myself and on the verge of vomiting. It's incredibly stressful. I don't know what I was a fact witness.
I enjoyed
in
it,
both
and I've
cases.
testified at, you know, depositions where they're going to use the, you know, not in a courtroom, but they use the testimony. Yeah, because I thought, you know, I have nothing to, you know, first of all, I'm going to tell the truth. And secondly, you know, if you're going to try to trick me, I don't think you're going to be able to do it. So, you know, let's try. So I kind of enjoyed it. And I didn't get nervous about it. Now, I wasn't on trial for murder either. Might be a different case if that were my situation.
I had
Why-
one where I
why-
had to report jury misconduct and be
Oh.
placed under oath and testify. And that was the
Yeah.
one where I was just like beside myself. Just
But
beside myself.
Why were you so tense? Were you afraid they're going to ask you trick questions or make you look bad?
No, it was I overheard jurors. I mean, it was in public court, so I guess I can say it. I was walking through the parking garage, and I overheard jurors deliberating in the parking garage, and they weren't all together. And I knew what case it was because I overheard them saying something that could have only pertained to this case. And ethically, I had to report it. And you know, the thing that really really bothered me about the whole situation is that I went to an older lawyer that I respected, and I said, I think I need to report this, and was expecting to get the whole, go get him, Tiger, you know, good for you, do the thing. And he said, is there any way you can forget you heard that? And I was just like, oh, wrong answer. So anyway, I had to testify about what I heard, and it was jurors deliberating in a sex crimes case, and it was a DNA hit from like 15 years prior, and they finally got the case to trial, and I was just beside myself.
You know, this
They came back
conversation,
guilty.
this conversation does remind me of something else that happened this morning that I was amused by. And that was Judge Everett talking about this, the prospective jurors in this case are not going to be permitted to talk to each other at all about anything until they're upstairs and the voir dire is happening and they're either impaneled or not. And as I said this morning, that's the direct consequence of Charlie's appeal, because his appellate lawyer pointed to at least a couple of cases where there was some discussion
Right.
as the prospective jurors were waiting as to what did you, somebody said he knew about the case. Somebody might have said, I think he's guilty. They did not follow the judge's instructions. And I remember saying earlier, Judy, I don't know whether it was on your show or elsewhere, that, you know, the motion, if they tried to change venue on that basis, it was going to go nowhere, because although there's merit to that argument on Charlie's appeal, I don't know that it will lead to a reversal. All that has to happen in Donna's case is that Everett makes sure it doesn't happen. And as long as he does that, there's no relevance to Donna's case. And boy, did he make that clear this morning. They'll provide them reading material. He's going to have more bailiffs in the room to pay attention to what's going on. So that part of this morning I was entertained by, actually.
Yeah, that's
Well,
a great idea.
Learn from old cases. I had an old judge that used to say the same thing to everyone with a restraining order. And I don't know what happened to him at in the frozen foods aisle of Publix, but it's always like, if you're checking out, you've got all this frozen food, and she walks in, you leave. And, you know, it's you learn as you've been on the bench and you develop your own little thing. So it's going to be interesting to me to see if he just adopts that in his cases in the future. It's smart.
Yeah.
It doesn't make jury duty fun, but it's smart.
Yeah, good idea. Okay, Sandra says, is it mean of me to say Zelman's paralegal shouldn't be at the counsel table? Perhaps they should sit behind Fulford to block the computer screen, since she was worried about it being looked at.
I don't know. I think that paralegal can sit at a table and help. The lawyers may need somebody to pull a file or do something quickly. They're focused on the witness. They're focused on what's coming next. I said this morning, and this was honest, that when they started talking about how are we going to block the computer screen so that people in the gallery don't read, and what are we going to do so we can't be heard, I stopped listening. I figured that those are details that the judge is going to work out to everybody's satisfaction, and I don't need to listen to, you know, all the problems and can we move the table over. And you can tell, even when I was trying not to listen, I heard some of it. Move the table to the side, and how are we going to do it? They'll work it out. And I don't see any reason why a paralegal shouldn't be at the table. If that's what the defense lawyers want, it does seem to me that judges should try to accommodate as best they can the particular proclivities of the lawyers as to how they're going to proceed at trial. You know, it's difficult enough when you're trying to manage a trial. And if there are things that the judge can do within, you know, within the constraints of the courtroom that make it more comfortable for you or easier for you, it seems to me there's no reason not to do it.
I agree. Absolutely right. And, you know, sometimes lawyers are older and there's tech involved. And, you know, when you're stressed out, the tech never works. So having somebody with a tech background that can always be working on it behind the scenes and making, you know, maybe running a test with some headphones before you play it, I mean, that is ideal.
Okay. How about this? If Donna is convicted, do you think she'll be as shocked as Charlie seemed to be? His confidence seemed to be pretty high until the jury walked in. I think she'll be very shocked. You know, remember that picture of her with her mouth opened wide? that people keep using on YouTube thumbnails. I think she is going to have some sort of big reaction if she is convicted. What do y'all think?
I think Charlie figured out he was going down in the middle of the closing, because it's possible that, you know, nobody had really put it all together for him the way that you put together a very strong circumstantial case. And it was a very well written closing. And if I remember correctly, I think they had like the whole weekend to put it together too. So it was, you know, it was flawless. And I really think that that's like the moment where he was like, oh no, it's over.
I agree. I think his demeanor changed at the defense table.
Mm-hmm.
Yeah. Well, he also said on the phone calls later that he knew he was going to be found guilty when they wouldn't let him put back on his tie and he had to come out in handcuffs. And so, and I think he didn't have a belt either. Yeah. So he said something was wrong and nobody would look at him when he came out. So he already had a bad feeling there. Yeah.
Well, the bailiffs will usually, I mean, when jury verdicts are announced in this jurisdiction, you hear like, you know, there's a beep and then you're told by the clerk or somebody else if it's a question or if it's a verdict. And in some jurisdictions, you just hear a beep and you have to sit there waiting on pins and needles to see what it is. So in this case, they knew that it's not a question. They're not asking if they can order dinner. They're not asking if they can come back tomorrow for a video or anything like that. It's a verdict. So that doesn't really shock me that they took that step away from him, because either way, it was going to be over.
Let's see. What about going back to possibly having Charlie testify for Donna? I mean, I kind of feel like that would make her case even worse for her because it would overemphasize how ludicrous of a story Charlie had. I mean, don't you think it's a bad idea to put Charlie up there? Like, what's he going to say? Tell that whole double extortion story again? It just sounds so stupid.
I can't imagine that he's going to say anything that undercuts his appeal. So I don't know how he's going to testify. I mean, I assume what they want him to say is, my mother had nothing to do with it. She didn't know. I deliberately lied to her. She's elderly. I didn't want her to have a heart attack. So whatever she did at my direction without knowing anything. But I don't know how he's going to do that without somehow indicating that he knew more than he tried to say he knew, and put his appeal in jeopardy. So I'm going to, you know, I'm going to hold judgment on whether he's going to get on the stand. I will be surprised if he testifies.
And keep in mind, he's going to be testifying, if he testifies for Donna, under a defense subpoena, which does not confer immunity.
Right.
So, and I also know his appellate lawyers, and I get the feeling that they would rather, you know, list a whatever horrible thing you could list. It's not going to happen. They will make it not happen.
Mm-hmm. Yeah. Okay. So can the defense use peremptory challenges for people who look too smart? Well, isn't that by definition a peremptory challenge? You can just use it.
Yeah.
You can use it for anything unless what you're doing is exhibiting racial or gender bias that can be shown by the pattern of the use of the peremptories. But yeah, peremptories mean I don't have to give a reason. It's not for cause. I just have an instinct. This juror won't look me in the eye. So I don't think this jury is going to be on our side. So you can do it for any reason you like until you use up all your peremptories.
And if the person is a member of a protected class, though, you better be ready to give a race or gender neutral reason for striking them off the panel.
Right.
Okay. So how many do you get, Katie?
This is a first-degree murder case. It is not a death case. So I believe both sides will get 12. Okay. I think that's correct. Yeah.
Okay.
Sorry.
That sounds good.
Rereading the rule in my brain. I was like, no, 10 is for PBL, punishable by life. It's 12.
Yeah, thank you guys, both of you, for being here. It's so great to have people with such specialized knowledge instead of, everybody just guessing about things. So,
Now,
okay.
I will say with regard to peremptories and for-cause challenges, some judges are a little more, I think what the right word would be, or less rigid about what for cause means. And they're more willing to give the benefit of the doubt that it's close, maybe not technically for cause. And so for that judge, if you know that's the judge's proclivity, you may end up having, you technically only have 12, but you may really have, maybe 2 or 3 more than 12, depending on how things go. But for anybody who's not done a trial, the peremptories, you have to be careful because you don't want to use them up and then find that there's now somebody who's you can't get rid of because you didn't correctly calculate how many you needed, which the state was going to use their peremptories on. So you have to be careful about how you're using them to be sure you have a sufficient number to be able to exclude those jurors you really have serious doubts about.
I used to list them and say, who's my biggest nightmare? And then kind of move on from there and try to figure out how to not, if that person's at the end of the panel, then it's fine. But it is really interesting if you've ever talked to a jury consultant, and I know that they had one in the prior case, but I've actually been a party to these mock trials where you, and I actually had one that was really interesting that we did down at FIU, where we paid people $100 each to come in, listen to a case, and then deliberate, and then videotaped them deliberating. And it was fascinating to listen to them. And the thing is, people would kind of you would realize that certain demographics, oh, young women with children actually really like this case. I wouldn't have thought that. And across race, across, it happened to be a child sex case. So that was really something we were looking at. But it was really, really interesting to go through it and to look at the dynamics. And then you can try to bet on who the foreman was going to be. It's like a study in human psychology.
Yeah, I agree. I also, for another sort of pull the curtain back a little or drape back a little, the other thing for those of you who play cards and can't remember which cards in the deck have already been used, you have to be really careful. You've got, what the prospective jurors said in voir dire, and lawyers have different ways about taking notes about it, but you've got to be on the ball and paying attention. And you can't sit there and say, now, gee, I don't remember whether it was this person or this person who said something I really don't like. And, things are going pretty quickly. So I think jury selection, I don't know how you feel about it, Katie, but I think that's one of the most stressful parts of the trial, to be able to keep track and know what you're doing and get the jury that you think is going to be most likely inclined your way. And, we talk about it all the time, that we are looking for an objective jury, and that's really just not quite accurate. Each side is looking for the jury that is going to be most inclined to vote their way or most receptive to the type arguments they're going to make. And we hope that because you've got that on each side, that the result in terms of 6 or 12 jurors talking and discussing will end up being objective. But no lawyer who's doing voir dire is looking for an objective juror if she can manage to find people that she really thinks are at least inclined to be more likely to believe, their story or the situation that a defendant is in.
So speaking of voir dire, I recently, it kind of, shower thoughts kind of hit me in the shower, that the reason Rashbaum may have used the jury consultant is because most of his background is in federal court. You don't do voir dire in federal court. You don't, as a lawyer, you don't interact with the panel the way that you have the ability to do that in state court. And depending on how far your judge will let you go, some further than others, but it's, in federal court, you submit the questions to the judge and the judge asks them for you. So he may not have had a lot of like back and forth interaction with jurors experience and felt more comfortable with a jury consultant.
Well, then he should have picked different jury consultants.
Yes, that's what I was going to say. Someone from Florida, from Tallahassee, instead of from New York City. That was strange.
Who then finished their job and left, and the jury never saw them again. I mean,
Like ultimate carpetbagger, right?
Yeah, that's right.
And I think it also emphasized how rich and privileged Charlie was, to have this huge team of, 5 or 6 people in suits with their briefcases and stuff, coming on down to Leon County for him. So, yeah, it looks like they finally decided for Donna, they're not going to do that same mistake.
I'm trying to remember this now. Didn't they keep somebody who's retired law enforcement on the jury? I have
Or
this
whose
vague.
family was law
Maybe.
enforcement, was somehow
That sounds
related.
familiar.
What, Katie?
Or whose family member was law enforcement, was
Yeah.
somehow related to them.
Yeah, I mean, I should go back and look at the voir dire, but it seems to me there was someone at that jury who had a background that you wouldn't typically think a defense lawyer would want on a jury. Clearly, your number one category might be law enforcement. Katie, if you were making your list of, if all you were going to do is occupations or professions that you'd want to keep off a jury, if you were a defense lawyer, which category would you start with?
On a general criminal case or on something specific? Because it really, something specific, but on a general criminal case, because I've defended ex-law enforcement and, people that are detention deputies and stuff like that. So that who, may have had some sort of sympathies in that direction. But yeah, cops. Interestingly enough, I've found that people that work for criminal defense attorneys will convict somebody really fast.
Well, they know how the sausage is made.
Right. Or the wives or husbands of criminal defense attorneys.
Yeah.
Yeah, they're just like, get rid of them.
Okay.
So,
Well, how about this question? Can Donna still take a plea?
if she were to take a plea right now, the judge would have to, so the rule is the judge has to accept a guilty plea. A judge can decline to accept a no contest plea. So she stands up and pleads guilty to murder 1. There is only one possible sentence in this case, and that's life. And that's also the top sentence if she goes down at trial. So without an offer from the state that's palatable, I can't imagine that she would eat a big bowl of crazy and do that.
But in terms of when she could potentially make some sort of deal, isn't that all the way until the whole case is over, like the defense rests or before the jury deliberates?
I've seen people take pleas mid-trial.
The judge, as you said, the judge has to agree.
Right.
I mean, the defendant can always plead, but you're going to plead to the indictment at that point if the judge doesn't agree. Yeah.
And in this case, you plead to the indictment. It's murder 1. It's a life sentence. Yeah, you need a little bit of finesse.
Yeah. So it's not going to happen anyway, where she's like, okay, I'm guilty. Yeah, not going to happen. Okay. Well, how much of an issue is her age in convicting for some jurors?
That question comes up a lot. And I was on a panel once with someone who thought that older jurors would be really sympathetic, and therefore Tallahassee was a good place, Florida was a good place. I don't think that's the case. If she's going to get on the stand and portray herself as so naive and so unable to make independent decisions and so likely to follow her son's lead no matter what it is, my instinct is you're going to have I would say most senior citizens are going to feel I'm independent. I do all these things. If, I just don't believe it or if she did, she deserves what she gets. So I think younger jurors would be much more likely to be sympathetic to that, because I think they think anybody maybe over 50, is ready to be buried and couldn't possibly even do a grocery list without help.
Isn't that, it's very similar to historically speaking, the Lizzie Borden case, where it was all men on the jury and they would never believe that a woman could commit such a terrible crime. And the point was, if you put a jury full of women on there, she would have been gone. Like, like how many times a day do I think about killing somebody? I don't plan it, but like, yeah, 100% she could. And it's just, I think that's a really, really good point, Professor, that younger people might have a lot more sympathy and not ascribe as much dexterity.
Yeah, or at least be sympathy or not, at least be willing to believe that at her age, it's very believable that she couldn't cross the street on her own, and therefore, succumb to whatever her son wanted her to do and whatever explanation he gave.
Yeah, I just recall years ago, there was a commenter who said, why does everyone think that, Donna's so frail and she's going to die in jail and all that, because I'm 74 years old and I feel just fine. And, so yeah, I totally agree that if you get older people on the jury, they're not necessarily going to feel sorry for her. They'll be like, I'm not so stupid to believe what my son would tell me if he told me a ridiculous story. Okay. Okay. So someone asked this before, but why is Donna allowed clothing that's not regular jail clothes? They have allowed her special clothes, as Professor Joe.
Yeah, I can't confirm this by anything I've seen in writing, but I have heard people comment that the jail officials have allowed the lawyers to come in with different clothes, and she's been trying on different outfits, and that they think it's extraordinary. That's not typically done. Now, Katie, you would know better than I whether that's done more frequently than the commentators thought. Again, so what? If she wants to have different outfits to wear, I just think it's a sideshow to get, and I'm not suggesting that the person who asked it, didn't ask a valid questions, but I just do think if that's what she wants to do, if they want her to try on clothes, if she wants to feel a little better, when she's at trial, then fine. And I would say that the case with any defendant. Now, the difference is she's got the money to do it and other defendants don't. And that may be a reason why jails don't typically permit it, because then you get an imbalance, not in a particular trial, but an imbalance as to how defendants are able to present themselves. But Katie, do you know if it happens regularly or frequently or at all?
Yeah, in higher profile cases, like where a hearing might be transmitted over the internet, and not just to the people in the courtroom, where you're worried about the just people seeing, I hate to say it, your run-of-the-mill murder case that's not going to be streamed on the internet. There's really not much of a need, but recall that Brian Koberger in Idaho was allowed to do that at his hearings as well. I believe they allowed Cruz to do that at some of his hearings. It just, if it's requested, you do it. I will say that some of it is you go to law school for law stuff, not to be a fashion consultant, but it usually does fall on the defense attorney to try to figure out what is this person going to wear. Yeah. And a lot of times their size changes dramatically in jail. For example, Donna, admitted that she gained all this weight. And I have to imagine that that's got to be just so uncomfortable to say, how much weight have you gained? What size do you think you are? Okay, this jacket I'm wearing is a 10. Why don't you try that on? And, try to figure out what size maybe I ought to get you, or try to fit for you to.
That's a good point, though. None of the clothes that she had before she came into the system, she won't be able to wear any of them. So there is going to be a need to do something so that she has clothes to wear when she comes, when she sits at counsel table, whoever is bringing them in, and she's going to move likely, and she's going to have to try them on, because I don't know that she would know what size she is now. She's been in jail attire the whole time.
Yeah, I mean, I feel like I'd probably just give her my jacket in court and say, okay, we know what size this is. How is this fitting you? What are the
Right.
sleeve lengths like? Let me go from here.
What do you do with the pants though, or the skirt? I mean,
So that's,
she's got to come in with, you know, she's got to be fully clothed, not just from.
well, yeah,
Yeah.
but like you
Waist
can start with a jacket at the very, yeah. I mean, and that's like so uncomfortable. I have a client who's male and like 6'4" and has been in custody for the past 2.5 years. And I'm like sitting there looking at him going, I know you've gained weight and this is going to be really uncomfortable when we're facing
So-
down at trial.
So, Katie, what do you do for clients who might not have the right clothes? Like, do you ever try to solicit like clothing donations from someone that might have the same size as your client?
So interestingly enough, the public defender's office actually has like a clothes closet that they keep in the courthouse for their clients. I would probably, as a private attorney, I'd probably go out and try to buy something, but I'd also try to grab a couple things, like maybe from Goodwill, to have them try on for size, and then go out and buy something based on how that fit them. I'll also tell you that I'm spatially stupid. This is an ongoing topic of conversation in my family. Spatially, I cannot do things. So I'm probably not, maybe I'd get an investigator to do it with me. I'm just not good at what's going to fit and what's not.
Yeah. Well, even in the civil context, I constantly tell my clients what to wear to court because I have had clients show up in sort of inappropriate clothing. Like once I had this race discrimination, housing discrimination case, and my client showed up in this really raggedy, like 2-pack tank top with a gold chains and, you know, saggy jeans and stuff. I'm like, this is not how you want to present yourself when this is the first time the defense attorney is meeting you and you're being deposed in a discrimination case. So anyway, there was also one time ages ago when I interned for the DC public defender, and I actually brought fake glasses for one of the witnesses to wear. So, you know, she got a kick out of that. But I was like, yeah, I got these glasses. I'm going to make her wear them. So I'm sure Donna's going to be wearing glasses. She has been wearing them quite often. So, yeah, but that's interesting to hear. You know, it's about client presentation. Yeah.
Well,
Yeah.
I mean, it's the trial is many, 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 many years ago now, but the Menendez brothers were dressed in sort of nice little sweaters to emphasize their youth. You know, they didn't come in suits and ties. Yeah.
Sweaters.
Yep.
Yeah. Weren't they pastel colored sweaters?
Yeah.
I seem
Yeah.
to
Little
recall
pink and
that.
green.
Yeah. Okay. T. Cancella says, what do you three think the defense opening will be? The theory, will the opening be a surprise like Rashbaum? I don't think it's going to be a surprise because the most rational thing to me is for her just to say, look, I was just doing what my son asked me to do, and I had nothing to do with it. I'm just a kind grandpa. And that's what Mona and I were reenacting when we did our comedy trial prep. So that's what I think they're going to do. They'll paint her as this very sympathetic, kind of simple-minded grandma who just loves her grandchildren. She loves her family, you know, domestic coordinator, worked hard for the family business, and, you know, she loves her son and trusted him. So,
Well, all I
what
can
do you
say
think?
is if it's a surprise, they are extraordinarily creative, because I have not heard any commentator who talked about this case who has another idea of how they can handle their defense. So if they've got an idea that no one has thought of, then they're extremely creative. Now, maybe that it's not a good idea, but they certainly will be creative.
Well, I mean, it's a very good case for the state. So, I mean, it's kind of a, you know, a swing away situation if you're on the defense side, in my opinion. But the other thing is you know, a lot of times I'll say that, like, as a defense attorney, a lot of the conversations you have with your clients is sitting down and saying, look, you know, I'm on your side, right? But let's talk about this evidence here. And this is very bad. What do you want me to do with this? besides like burn it, that's not happening. Like, I mean, there's no such thing as a motion to change the facts. So, I mean, a lot of stuff happens in the office or in the jail where you sit down and you say, you know, that was not a helpful statement, buddy. And you kind of say, and I don't think there's a way that we keep it out. I could try, but I just don't want you to wrap your head around the fact that I'm going to be able to keep this out. So, I mean, really difficult conversations like that. And hopefully they've had them with her.
Well, they're not very, I mean, it seems to me if they haven't had them, they're not doing their job for their client adequately. You said they were hard, and I'm sure they are, but you're clearly correct. You've got to have them. I mean, I keep wondering, and I know others have wondered the same thing, whether Katie McBeno's lawyers really gave her that come to Jesus moment about here's what the evidence looks like. This deal is a terrific deal. You won't have to spend a moment in jail. You'll be able to, or prison. You'll be able to raise your kids. You'll be home with them. You know, Sigfredo is likely going down. And she didn't take the deal. It's extraordinary that she didn't take the deal. And, you know, you always wonder whether they pushed her adequately or counseled her adequately, or looked at her in the eye and said, you know, this is what you're looking at. And I know from that trial that it sounded like Tara Kawas really thought she was factually innocent. At least that's the kind of presentation she made. And I think she said things may have said something after the trial, but boy, I don't think you're doing the job if you don't do that. I mean, that's what you owe them. You owe them your professional expertise and your best judgment on the law. And if you don't give them that, you really haven't been doing your job well.
Well, you also need to get to a point personally as a defense attorney. And I realized that I was finally a defense attorney when I realized that I don't care if you've done it. All I care about is the Constitution and everyone doing their job correctly. Mm-hmm. And everyone's rights being protected. And so it starting off at that point is a little bit easier to say, like, this is not a confessional. I am not your priest. You do not need my forgiveness. Let's have a very serious conversation about this.
Yeah, Kawas seemed to have more like a big sister relationship with Katie, and it just seemed like she kind of crossed the line into wanting to be Katie's friend. And this was, you know, around the time that Katie's mother died too. So I don't think that helps when you become like a buddy or family member toward your client.
You have to remember what your role is. And, you know, at least the stories of Daniel Rashbaum with Donna were the same thing. You know, he described on the STS show when he was interviewed that he thought of her like a second mother. Well, you shouldn't be defending your mother in a murder case. Right. You just shouldn't be doing it.
Yeah, it was weird that he mentioned that he and his wife would have dinner with Donna. So why are you socializing along with your spouse with your client? It's just strange. Yeah.
You have to have a little bit of professional distance. And in the past, I've had cases that I felt I have gotten too close to, and I have brought on other lawyers to essentially supervise me and make sure I'm making good choices, like child sex cases where I just feel like this is my kid. When I was a prosecutor, and I'm just like, and I can't leave her. I can't assign her to another prosecutor. So I bring on another prosecutor and say, it is your job to make sure I don't do something emotional here.
Yeah, good idea. Okay. Well, this is an interesting comment. Donna was afraid when she was arrested at the airport, or she wasn't afraid. She was so annoyed they stopped her from leaving. And this is why I sure hope they show her arrest video to the jury, because her reaction doesn't even look like that of an innocent person to me, you know, where she's just like, not again, or this again, something like that, where, just weird, again, that demeanor does not exude innocence to me. So, this is an easy question. Yeah, that writer Steve Epstein said it was because they didn't videotape his arrest. So Could that be true, Katie? What do you think?
So he was arrested in Broward County in Fort Lauderdale, actually close to where I grew up. But it is in Fort Lauderdale police's jurisdiction. And they, because of all the, essentially the crap that they knew about Charlie and running his mouth and the guns and the drugs and the blah, 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 at the house, and the fact that they knew that he was becoming more paranoid and all those things, they sent in a SWAT team. That SWAT team did not have body cams on because they were more concerned about removing the person from the house than filming it for evidence. So that is the answer to that.
On the other hand, Charlie's such a litigious person. Don't you think they would have wanted to record it in case he made some false claim about how they treated him?
I mean, you don't change protocol because somebody's a whiner in law enforcement.
Or likes to sue.
Yeah, but it's like, I mean, I assume there's another thing that, like, there may have been body cams available. Like, I know we started using body cams in Broward for all the police agencies around 2015 or 16, something like that. So they would have had them, but SWAT, special weapons and tactics, they do not want anything about their tactics or how they breach doors or how they surround the house. And, you know, you remember Charlie talking about, like, there's people in the backyard and blah, 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 that there's no way that they're going to broadcast that. So it's possible there was video and it was something that was not turnoverable under Florida Statute 119, which is our public records law. And it's also possible that they just were like, yeah, I think I'm going to be carrying so much extra ammo that the camera's superfluous.
Yeah, it's just more weight. Okay. Not to be a Debbie Downer, but what do you think are the chances of a hung jury?
You know, it's always possible to have one juror who just has a different take on the case and cannot be persuaded. That was Katie McManus' first jury, the hung jury. The woman who would not vote for conviction was someone who was quoted as saying she couldn't see herself removing both parents and leaving children, you know, without either parent, and could not be moved off the dime. Typically, that doesn't happen. Typically, if you only have one or two holdouts, the rest of the group, you know, you go with the group. It may take a little while, but they tend to, all the jury studies they've done is if you've got two or three, they tend to move towards, you know, where everybody else is. But, you know, you can always have somebody like that. And but the chances of it happening in any particular case are not high. It's just something that you can't count out completely. I think the evidence is really strong, so I will be surprised certainly will be shocked if she's acquitted. But I will be surprised if it's a hung jury. Yeah.
Katie,
I
you
agree.
have any
In this jurisdiction, I agree. In a different, larger city where, you know, it's just so easy down south for one juror to ruin a case.
Okay, so let's get to this week's big news on Brouhaha. Cliff Frankenberger wants to know, ask Professor Joe how to opine on the potential plea discussions. Are the state and defense responses half-truths?
I was on that panel.
Yes.
And none of us, not Julia Janae from Court TV, not Joel and not I, knew what Tim was going to be reporting. And I will give you my view of this. I have no doubt that Tim believed what he was saying, and I have no doubt that he talked to someone that he thought was reliable. Those two things I just have no doubt about. I think Tim is a really, you know, very upstanding, credible individual, and I don't think he'd risk, and in any event, I don't think he'd risk his reputation on something like that. After that, for me, it gets a little murky. And on that panel, I asked at the end, I said something along the lines of, don't you generally need to talk to the victim's family before taking a plea. And Joel earlier in that program had said he had talked to Phil, and Phil didn't have any notion of a plea. Now that had been a few days earlier. And Tim opined that maybe it hadn't, coalesced completely in terms of a plea and a response or rejection from the defense. And I think I heard Jack Campbell at one point, maybe it was not he, but somebody said, and Katie, you can nod if this is correct information, that there's a statute in Florida that you do have to consult with the victim. Yeah, so
it's enshrined in the Constitution, actually.
Right, that's right. So that the idea that it could have been a firm offer and a firm rejection with no wiggle room when the victim's family didn't know, makes that hard to, it makes it a little hard to see how that could have happened. On the other hand, that sort of chatter goes on. It isn't as though it's only a case here and there. The idea that there might be, plea talk. It's not formal. It's sort of informal. And I was trying to recall, I thought I remembered, and I'm sure people in the chat will correct me if I'm wrong, but that second set of attorneys that represented Donna for that short period of time before they were off the case also, one of them, Alex, don't remember his last name. Anyway,
Morris.
That's right. Outside the courtroom, when they asked what he was going to do, and he said, well, something along the lines that the first thing I want to do is talk to the prosecutor about maybe getting a plea. And then I think they talked to Jack Campbell, who said something along the lines of, well, we're always willing to talk. So I don't know what happened here. I don't know. I have no idea whether Tim's source was on the defense side or the state side. But I think you can take all the statements that were made and make them, from everybody's point of view, still make them all fit in the same sort of general pattern. Tim's source said plea and rejection. Now, he may have overstated, or she may have overstated, or may not have been clear enough about how far the negotiations had already gone. It's possible that Tim may have heard it a little more strongly than that person said it. Josh, what is his name? The defense lawyer said when he was interviewed that there was no firm offer or formal offer made, which is not saying there weren't any negotiations back and forth. And however emphatic that Jack Campbell was, if you're talking about whether there was a firm, here it is, yes or no, they may be all, from their perspectives in a wide range, being accurate about it. That's where I come out on it, because I do believe that people generally are ethical. They're trying their best. They're honest. Of course, you can get a bad apple. But I don't start out believing that people are misrepresenting or lying or acting, or deceiving or any of those things until there's firm evidence that that's how this person operates. So to get back where I started, I think Tim thought he had that scoop. He thought it was clear. I don't know. He may still believe that it was clear. I mean, he knows better than I how firm and how clear his source was. But I don't think it's a case of anybody doing anything to upend a trial or to help one side or the other, or to do anything to do what they thought was reasonable and accurate. That's how I come out.
Okay, thank you. Well, I do recall Tim said his source was from the state, which again, Jack Campbell refuted that and said that,
Yeah, I don't remember him saying that. If he said it, I didn't hear it. So
okay, I thought he did.
I wonder.
Yeah, he may have. I don't want to quarrel. I just don't remember him saying that.
Yeah.
Okay, sometimes Katie? In like CIA movies, they'll give wrong information to some of the people to try to figure out where the leak in the team is.
Yeah.
But I don't know if they're, that cloak and dagger at the state attorney's office. But my the first thing I said to Judy after I heard this was, I can't understand why someone would tell this to Tim this close to trial when they're trying to keep the venue here.
Right.
And why somebody would ever give him this information. I'll bet it's the last time anybody ever talks to him about this stuff. And then when he said, oh, and they said it was okay if I said it, I said, oh, maybe Tim's the new bump. Don't take the bait, Wendy. Don't talk on the phone. It's bugged.
Do you have a different take on it, Katie, than I do?
Yeah, I don't know. It's entirely possible it was like a miscommunication where somebody said, well, it's not like she'd take time, even if we offered her time served, she wouldn't take it. And then Tim, in his head, that coalesced into something different. And it was said in a way that.
Or the person who provided the information might have misheard, misunderstood.
Yeah, it's a game of telephone.
Yeah. The game that kids play where you start a story and it goes around, by the time it comes around, it's a totally different story. I mean, people of good faith and intelligent and are doing their best, you just hear things a little differently. You say things that are not as clear as it could be. So I don't know how, Tim thinks it was very firm. I believe that's what he said. And I don't dispute for a moment that he's telling you the way he saw it and the way he heard it and the way he thought it came down.
Okay.
Well, somebody in the chat said that Jack did call it like a bold-faced lie or something. So I mean, that was pretty definitive that he was trying to say that did not come from us at all.
Okay. Well, would this even jeopardize the trial location? What do you guys think? I don't think it has any effect.
Well, it does bring public attention on the trial right before the trial is starting. Yeah. I don't know whether in fact, I think the information that she rejected a plea, if anything, I think you could argue that it would be helpful to the defense side, that if a potential juror knew that this defendant rejected a plea, you might say to yourself, well, maybe she's innocent, but that juror shouldn't be sitting. But so it's gonna take a little more work to ferret it out. And you heard Judge Everett this morning say they're going to take, he said, morning, afternoon on the pretrial publicity part. And so this is going to come up when they talk to the jurors, and they're going to do their best to be sure that no one has heard it or made a judgment one way or the other on the basis of it. But I do think, Judy, the fact that it's publicity about the trial this close to, sitting a jury is something you don't want. You'd rather have it be quiet until you're there with the jury and trying to get a jury seated.
Right. And Rebecca is from Tallahassee, so she says very few people in Tallahassee follow the case, contrary to social media thoughts.
Right.
Yeah, I mean, for those of us that are lawyers, like I'm a lawyer, married to a lawyer, the child of 2 lawyers, and my sister's a lawyer. So it's rough in our house. But for other people that are moving on with their lives and actually have like real jobs that don't focus on the courthouse. Yeah. I mean,
who want to be out playing softball or, going to a movie or taking a vacation or playing with their kids. Yeah. I mean, we all have busy lives. And so I don't understand it because I find it all fascinating. And I don't understand how somebody couldn't squeeze this in too. But that's not true of most people. Judy, you said you can't get your friends interested in it. Yeah, I thought I heard you say that once. Yeah.
That's right. Yeah. Nobody cares. Yeah. Which is sad because we care, we're fixated on this case. Yeah. So I'm trying to see if there are any other questions out there.
I did like the comment that said the blog was Tim or something like that.
What was it?
The blog was Tim as opposed to the blog was Wendy.
Oh, okay. Greyhound Lifesaver, she's an attorney also. She says no effect on venue if Kyle Rittenhouse and Derek Chauvin didn't get a change of venue with threats of cities burning down. No one should ever get a change of venue.
Yeah, I agree with that. I just think it's going to take them a little longer to do it because they now have another, column of questions about pretrial publicity that they're going to have to vet.
And I recall the last case I really remember in Florida changing venue. that I remember that obviously high profile was Casey Anthony. And if you recall back then, the child was missing for 4, 5, 6 months before they found her body. So it was so front and center. Here is this kid's picture. Please look for her. All over the state. There were Amber Alerts. There was, her picture was everywhere. And so that one, I can kind of see it because there was that ongoing, bombardment with please keep an eye out for this child that, her mother reported that she was essentially kidnapped. So this healthy, alive child that, was kidnapped by a nanny. So, and that did kind of make sense because the press in the Orlando area, an adorable child. It was just, wall to wall coverage.
Yeah.
A different.
So, but they didn't change the venue, did they?
They did.
They did from where to where?
Yeah, I think that and so my memory is, and this is how long ago it was because I was like TiVoing the trial when I was in court. But I believe that they bussed in jurors from another jurisdiction. They may have bussed them in from Tampa to Orlando.
Yeah.
Or different city, and left the trial in the Orlando courthouse with jurors from out of the area.
Okay. Another question. If Wendy would not have given a police interview or refused to testify and plead the fifth in all 3 trials, would she have been arrested a lot sooner? Do you think state keeps her around to testify? Well, she couldn't plead the fifth because they gave her the immunity deal, right? The limited immunity.
Yeah, if she refused to testify, she'd be held in contempt.
It's not up to her to decide whether she's going to testify or give the information or not. She's got the Fifth Amendment privilege, and if they don't give her an immunity, then it's completely up to her. She's got a right to be silent. But once they say they're going to give her immunity, that erases the privilege. The privilege is you can't be forced to testify against yourself or give information against yourself. The state wants to force you to testify against yourself, but they give you immunity that says we can't use it. And that means it's as though you didn't say anything. You're not being forced at that point because there can be no criminal consequence. And so she doesn't have the right to say no at that point, and they can hold her in contempt. And then the issue will be, how long can you be held in contempt? And, can you keep renewing it? Because she keeps refusing. In the mob cases, that used to be an issue. They would prefer to be held in contempt of the grand jury. The grand jury would be giving the immunity than to run the risk of being shot, killed by the mob because they became informers. And so there would be a new grand jury impaneled, and they would issue the immunity again, and back to prison the informer would go because the informer would not testify when they had no right to say no. So long story short, she couldn't do it.
Yeah. And I think,
remember correctly, it would be direct criminal contempt of court, so that you could be held in contempt immediately and you're not entitled to an attorney. So, you could get up to 364 days in the county jail immediately. And then once you're done serving that, we'll revisit your testimony.
Yeah. And I'm trying to remember, there are a couple of Supreme Court cases on this. My memory, I shouldn't say it because my memory might be wrong, so I'll just keep it to myself.
Okay. Yeah. I think she's still needed as a witness, of course, to testify. And that's what my prosecutor friend from California said, is that, look, she needs to be there to lay the whole background and foundation of this case and the motive for the murder. Looking for questions here. Sorry. Feel free to jump in if you have any comments.
Well, there was a question about when is the Castigar hearing on
yes.
Wendy, and the answer is she would have to be charged first. I've never done, they're unusual. To find a lawyer that's done one. I know a lawyer that's done one, and he was in our public corruption unit in Broward because there's plenty of public corruption in Broward. And he, back in the 80s when there was a lot of, money and drugs going on. And he told me it was, he would have rather personally pulled out each one of his teeth with a pliers without without any kind of Novocaine, then go
Yeah,
through
let
that.
me
That
talk a
was
little
very,
about
very
this. Yeah,
vivid.
let me talk
Yeah.
a little about this. Use derivative use immunity, transactional immunity. I hate to use legal terms in here, but I want to contrast it. Transactional immunity means you can never be prosecuted for the crime that you're being forced to talk about. So if she'd been given transactional immunity, she couldn't be prosecuted for the murder. She couldn't be prosecuted for the conspiracy to commit murder. And I don't remember what the third charge is, but couldn't be prosecuted for that. There was a Supreme Court case many years ago when a state first gave what's called use derivative use immunity. And the defendant in that appeal said, this isn't good enough because the Fifth Amendment says you can't force me to testify. And the Supreme Court said, as long as the state cannot use in a criminal prosecution anything you say and anything they could only have learned because you said it, you've got the full protection of the immunity. And if they can find the evidence a different way from a different witness, something you said before you got the immunity, that's perfectly fine because it didn't come from you. Even though you were forced to give information, the information we're using against you is in a different silo. That's the way the law works. What Katie is talking about is that's fine in paper, but the issue is any particular piece of evidence they might want to use, the state will have to demonstrate that they did get it independently, because
And that's
you can't use it if it's not independent. Now, anything that Wendy said before she was given the immunity, that first interview with Craig Isom, because clearly that it was not a product of the immunity. Anything anybody else said, independent of, but police didn't go at, law enforcement didn't go after them because of anything Wendy said. But Jeff Lacasse comes forward. He didn't come forward because of anything Wendy said that led the police to him. He came forward independently. Those are all easy. But there's going to be a sort of a little pile of evidence in the middle where the defense will say, you got that because she said this. And the state will now have to show that it got it in a different way. She may have said it, and they may have been able to follow what she said and have gotten it, but they did not get it that way. They got it another way. So that's what Katie's talking. That's the area where if she's going to be prosecuted, where they're going to have to get all that cleared up before, and then the likelihood is even a trial, there will be objections.
Excellent explanation.
Well,
and
thank you.
the hearing itself is just, I have been told, is mind-numbing.
Yeah, what you have to do,
having to put on all the
Right.
evidence in the middle part.
what you have
and
to
have no
do
witness.
is try to segregate the information that you know before. The better you're able to segregate all the other information so you can show it couldn't have come from her testimony, the easier it is. But that said, there are going to be things, I mean, let's take Donna's case. As of October, they have new information from that new investigation. So evidence keeps constantly being developed. You don't stop developing the evidence until, maybe the day of trial, maybe even later than that. So you're going to have to prove every piece. The state has the burden, and the judge will, if it's not clear, the judge is going to lean towards not allowing the evidence to be used because that protection of the privilege is extremely important.
So, and if you're an extremely clever defense attorney, here's what my argument would be under Castigar, or on the Castigar hearing. A lot of this evidence you got because other people were convicted. So you got Donna's cell phone because other people were convicted, because you got the information from Charlie, who was in custody. The reason Charlie was in custody is because he finally convicted Katie, and she finally gave a statement to the state. The reason Katie's in custody is because you found Sigfredo and Luis. All these, because of the first conviction of Sigfredo and the flip of Luis, happened because of Wendy. Because of Wendy's testimony in that first trial. You would never have gotten the first conviction. You wouldn't have gotten the second conviction without Wendy's testimony. So that is the argument that I think is possibly the most evil argument you could make on the defense end. Probably shouldn't even be saying it, but to try to.
That's way too expansive. I mean, she didn't.
Yeah, I mean, but like
at all.
But you swing for the fences on the defense end. This is a very strong circumstantial case. But that's the argument you should make, is that, you know, but for Wendy, none of these other convictions happen. He wouldn't have any of these other witnesses, and you try to travel on that.
Mm-hmm.
I think that's a big stretch to say they wouldn't have been convicted if it weren't for Wendy being a reluctant witness. But
yeah, I think they probably could have made the case otherwise. Wendy was probably just the cleanest, neatest way to move the storyline along.
Yeah. But that's a creative defense attorney way of thinking. I sure hope that it's
nobody's listening.
Yeah.
I don't know. It's a loser argument. What do I know? So.
Yeah, it will be difficult. This comes up in congressional hearings because Congress will call somebody in and they say, well, now we're going to give you a privilege here, testify. And now the question is, prosecutor wants to prosecute. Is every witness who's going to testify tainted because they might have heard the testimony at the congressional hearing? That got way back in Watergate, it got some of the Watergate defendants. They weren't able to prosecute them because they testified before Congress, and the government could not demonstrate to the satisfaction of the court that they found the information another way, which is why it's important, to the extent it's possible, to segregate you put it in a box and you lock the box with a key, because then you can open with a date on the top. It's like a time capsule. So I can show you this couldn't have anything to do with when she testified, because look at the time capsule. We got it before. We got it we got it some other way. It's unclear to me how much, I mean, she said a lot in that first interview with Craig Isom. And the other part of this is she only gets to assert the immunity if she testifies truthfully and she testifies fully. So to the extent she can be demonstrated to have lied, that doesn't mean, take the statements she made about did she turn on Trescott, did she not turn on Trescott. She's got four different versions of that. It doesn't mean that any of those are outside the immunity, because to be outside, you'd have to prove that she intentionally got on the stand and perjured herself. And we talked about this just before. People misremember, they're not clear as to what they say. You can read in or read out some of the things people say. There are all kinds of reasons that would not go to showing that I actually intended to lie. And that's what you're going to have to show, even with regard to the different statements. So
you don't see a lot of perjury. You don't see a lot of perjury prosecutions, because the elements are that you said one statement under oath and then you intentionally lied under oath a second time.
Right.
And if I said the car was green and I meant to say it was blue and I made an error, that's not lying. That's human frailty.
Yeah, and Wendy was smart, because she'll always hedge her language and say, I think, or I'm not sure, or it might have been, or it was a long time ago. There's
very
always
good
a qualifier.
Very good point, Judy.
Yeah.
And if you go back and listen to her testimony, you're exactly right. That's how she testified.
She even said, I think his middle name is Jay.
I know.
About the brother. And I'm just like, no, I know my brother's middle name.
Yeah. Okay. Do you all think the prosecution has more evidence? Yes, I totally have faith. I'm pretty sure. Yeah.
I don't know.
I mean, we don't know. We're just guessing. Yeah.
I think so.
Supposedly, yeah, because it kind of stems from when Jared Ross, one of Dan and Wendy's old friends, he said that he ran into Jack Campbell at some, I don't know, Dance with the Stars type of fundraiser, and he talked to Jack briefly about the case, and Jack just said there's more. So if that's true, it gives me hope. So this is just rumors, of course. Yeah.
Well, I mean, I think that there's going to potentially be, so none of the money that had to do with, like, you know, 'cause she played, at least from the prior testimony, she played hockey with some of their accounts. Like she was really messing around with money prior to the divorce, and where it was being transferred and what money she was hiding from him. And I think that has not really been fleshed out at all in trial. I don't know if they can make that relevant if they ever charge her, because some of it was done so far in the past with the divorce, but there was some money issues that were coming up in the divorce that he was trying to say, I don't need to give you the money for the house because you lied under oath about this other stuff. So I think that they didn't really flesh out quite what that was and quite what she did. They just kind of touched on it and moved on. But if she ever does have a trial, I mean, the forensic accounting is going to be interesting to me.
Mm-hmm.
Yeah. No, I think those financial issues had to do with Dana alleging that she failed to disclose some sort of Schwab account and didn't mention her car. And of course, there's that issue of her lying at her civil deposition where she said she would give back the ring if his great uncle wrote to her and requested it directly, which the great uncle did, but she still wouldn't give the ring back. But unfortunately, that ring wasn't mentioned as part of their whole settlement.
Yeah, and Judy, the reason, at least one reason for that, and the question is how relevant it is to Charlie's trial or Donna's trial, but independent of that, because of the immunity issue, if you're the state and you want to try Wendy, the last thing you want to do is ask more questions of her, because then you increase the world in which she can claim immunity. So you don't want to pursue those lines if you don't need to in these other trials. You don't want to ask her open-ended questions where she's free to, she didn't, but, you know, throw a lot more information in. You want to ask very pointed questions and stick to just what you need. I know it's frustrating because if you know the case, you say, well, why don't you ask her this too? And why didn't she push? But the immunity is a really strong reason why Georgia didn't push.
And the divorce file itself, if you go through the divorce file, they went as far as to depose the owner of the daycare where their children attended. And it was nasty. I mean, I can't imagine. I don't know if you could probably make it relevant at Wendy's trial to have that woman testify about how Donna was trying to feed the kids non-kosher hot dogs. And the daycare owner apparently stepped in and stopped her because she knew that was something that Dan didn't want and that was an agreement.
Well, if Donna testifies, it might be impeachment if she testifies about making him banana bread because, you know, all was copacetic between them.
Mm-hmm. Yeah. Okay. Well, can you think of any info Wendy gave on the stand that the state didn't already know? Yeah, that's a good point. Probably just when she said she only found out that morning about this extortion thing. Right? That's the only thing I can think of. Oh, and the banana bread. Like, oh, everything was great because Danny asked my mom to babysit and she made him banana bread and gave him a hug. I think those were the new things at Charlie's trial.
Yeah. And if you were Dan, would you eat that banana bread? Because I wouldn't.
It's not. Yeah.
I don't even think I'd feed it to the ducks.
Yeah. Yeah.
Not because she's a bad cook, because I'm afraid of what's in there.
And that, by the way, this morning when Georgia pushed to be able to show how extensive that file was, and said, you know, there were things in it that she'd want to use, it relates to this. It relates to the claim that Donna did not have a reason for wanting Dan dead. The divorce was over, you know, everything was fine. There's a lot coming out of how at each other's throats they were in that hearing, or in those hearings and those proceedings, that would go to showing that Donna's animus and motive didn't evaporate. And that's why you heard Josh Zellman say, yes, but there's no proof that Donna knew about all that stuff. And Judge Everett said can't go in the case in chief, which means that Georgia can't use it when she's doing the prosecution case. But if Donna gets on the stand and says some of these things, if Georgia can, if there's a foundation for it, if there's a way to believe that Donna might have known, she can ask Donna and Donna can say, well, gee, I didn't know anything about it. If Georgia has a way of showing that she did know, then it's pretty strong evidence there.
Sure,
At least
just
the forwarded emails is helpful. And then Donna actually attended several of the hearings, right?
Right.
Oh, yeah. And Rob Adelson is expected to come and testify too, so he could say that of course, the whole family knew every mindless minutiae about problems that Wendy had with Dan, and she constantly forwarded us every single correspondence with her attorney and all the legal filings. There always had to be multiple phone calls with mom and dad. Everybody was up in it, and probably they helped pay for her legal bills too, because Donna was complaining about paying Kristen $600 an hour.
Yeah.
Well, I mean, Judy, you can speak to this. Some of the most contentious cases that you could ever deal with are child custody and divorce cases. You want to see the clause come out, take somebody's kids away. And a lot of time, you can really see people behaving incredibly badly in family court.
Yes, exactly. Yep.
Yeah.
So it's possible you put on Kristen Adamson to say, yeah, this was bad, but it certainly wasn't the worst I've ever seen. Everybody goes crazy in family law cases, especially a divorce between lawyers. And my parents divorced each other as lawyers, so I can attest to that. It was awful.
Yeah,
right.
And the reason why, excuse me, go ahead.
Oh, no, it's just that, that everybody behaves badly in family court. And anybody who's gone through a divorce or has been a party or close to somebody who's been through a divorce should know that.
Mm-hmm. Mm-hmm. Well, a reason why Georgia is fighting about that file is the emails that they've used before are, I think they're mostly pre the divorce. And so the claim that I think they're making is, after everything was settled, Donald settled down too, and the animus died down. And that the file from the hearing demonstrates that it was nothing settled down between Dan and Wendy, and Donna knew that nothing had settled down. So the motive was still there. It didn't end when the divorce occurred and the custody agreement was worked out. It's the timing issue that I'm pretty sure is the reason why Georgia is, so adamant about getting that in, because otherwise there's clearly ample evidence in the record already that Donna didn't like Dan, that she wanted Wendy to move to Miami, all that. There's a lot in there already, but the timing issue, I think that file would help with.
Yes. Well, there were still some vitriolic emails in spring of 2014 that have become public too, where she was still complaining about, when is there an end to all this endless litigation and waste of the court's time and your time and our attorney's fees, complaining still in spring of 2014. So it definitely
that's the part of Sarah Yusuf's testimony that would be relevant to Donna's case if she's used as rebuttal, because it's Sarah Yusuf, they can talk about the animus was there even after Dan's death, because it was after the death that Sarah said, she said they don't really know what he was like. I mean, that in the timing is very useful.
Yes, I hope they call her. I think she's still very useful. Yeah. What about this comment? If it were all about the kids, Donna was willing to get Dan out of the way. Would she give up Wendy and walk free and still have the kids? I don't think so, because, she still has her pride and arrogance. I don't think she ever wants to admit that she had something to do with their father's death. Any
Wendy?
comments?
You think back to Katie, her test, the bad Katie, I'm the good Katie. But you think back to her testimony, and it seems like she fairly well convinced herself that she was not involved and that she was not guilty, because the only thing that she did was bring the money from one place to another and bring the piece of paper from one place to another.
Supposedly.
She knew exactly what she, well, even though she knew exactly what she was doing. And it's, you know, when I mean, it goes back to social psychology. When people in groups do things, you can kind of push the blame off on others. So Donna can push it off on Charlie.
I don't believe her.
You don't believe Katie?
I don't believe Katie. No.
Okay.
I mean, I you know, from what, and you could be, you know, mine is just a different take. You could be absolutely right. But I see her as more instrumental in getting Sigfredo to take the job. She didn't tell him it was coming from Charlie, although he, who knows, he may have guessed. I mean, I think she did more than just carry the money. She found Sigfredo for Charlie, and I think she persuaded him to take on the hit, and was just not this, you know, person that Charlie used and brought the money to Sigfredo. I just don't believe it.
Yes.
The Katie we saw on the stand was not the Katie that interacted with those guys on the outside. We saw the real
That's
Katie
how I
with
would
Dolce
say. You're
Vita
right. You said it much better.
video.
Yeah.
Yeah. Does the panel think Wendy has any insight into how her testimony is received and perceived by the jurors? Well, I think she did tone down her stupid facial gestures, or, you know, the whole open mouth, hanging open, you know, bulging eyeball type thing. Like, she didn't do it as much during Charlie's trial. She seemed a lot more serious and scared at Charlie's
I don't
trial.
see how she could not know. I mean, maybe she's telling the truth that she never watches any of the podcasts and isn't following any of this. But she's got to get a sense of how the jury, and you heard Katie saying earlier that a lawyer there can feel how the jury is reacting. My feeling is she has to have some sense of how it's going over in the courtroom also. So maybe she's not, maybe she's so unaware that she can be oblivious to all of it. But it's hard to believe, you know, that when she was in Tallahassee afterwards, and when she moved to Austin, and now maybe she's in Colorado, that she has not seen how her testimony is being received. And she's got a good lawyer, so even if she isn't perceiving, I can't imagine that he isn't saying something to her, you know, this is, let me talk to you about, this is how I think, you know, others are reacting to the quibbling and to the, you know, the way she testifies. I think she has to know something.
With all their money, you know, how Donna even has had those like social media analysts, or whatever you call them, consultants, then of course there's got to be people probably scouring the internet just to see, you know, what are people saying about the client, because Rashbaum knew about that comment that Ryan Fitzpatrick put on Facebook. Okay, what about this? This is for Katie. Does she have any confidence in Zellman, especially Jackie? Do you want to answer this? Katie might not have been in tally during Fulford's demise as a judge.
I wasn't. I was told about it by other prosecutors. I believe that she was off the bench in 16, maybe. And I moved here in the middle of 18. So she was well off the bench, and I've never seen her practice. But what struck me was, like, I practiced law in my kitchen for like 10 months during the pandemic. And my first trial back, I was really, really nervous and shaky, and all, you know, because I felt like out of practice. And she was, you know, years out of practice, and she came in guns blazing, was ready to, you know, there was no nervousness there. She was ready to go. And I, you know, I kind of, you know, I envied that a little bit. Nerves of steel to not have, you know, been in practice for 6 years and to just get right back into it like riding a bike. So I think that I look, they're both good lawyers. I've been impressed with the motions that they've filed. Certainly, it's work that other attorneys in the past have not put in on the case. And I think it's going to be a significantly better appellate record for appeal. I mean,
Have you
Charlie's got a
actually-
pretty good appellate case.
Yeah. Well, what about Zellman? Like, do you know him or have you had cases against him?
I've had cases against him. I do not believe I've tried an actual case against him. So I don't believe I've seen him in trial at all since the only time would be since I moved up here. So I can't really speak to that. I think I've done a couple of motions with him, and he's competent. He's very competent.
Okay. Yeah, I think that's what Mentor Lawyer also said, that Josh has a pretty good reputation. So, never understood why Wendy didn't just give Dan to boys. No, Donna had to have her sunshines. That family was like a unit. So I think it was also because of Donna. There's no way they would have just let Dan take the kids. Yeah.
Well, didn't
Oh.
she say, nobody, what is it? Nobody beats at Adelson, some line like that. About,
Yeah, no one,
yeah.
Chippers hasn't beaten the Adelson
That's right.
family yet.
That's right.
One of the things that I think we might see in Donna's trial that is not or was not an issue in Charlie's trial is going to be, so most of the schools in South Florida, it really depends on where you are for public school. There's some extremely good public schools, Marjorie Stoneman Douglas being one of them, unfortunately. And then there's some very, very bad ones. So to think about where Donna got them in school, considering when the homicide happened and when school starts, like how quickly were they enrolled in this other school, and was there a spot? Because I'm going through that with my brother. He's fighting about his kid and trying to get her into a school, and schools are all full now. So he's scrambling, and I think that that's probably a path that we're going to see, where Donna's kind of, especially as a former teacher, kind of sniffing around down there trying to figure out where there's a spot where she can get the kids in.
I've said before that I think that there are a lot of leads like that the state may well be looking at, because they knew that they were going to be moving to Miami. So there are all kinds of things you may want to do. You may be looking into movers. You've got, when you turn off the electricity, you're talking about the schools, where are you going to live there? I mean, there are all kinds of things that are attendant on moving that you have to do. And Donna is so meticulous. And so let's check every box, that I think, that there's fertile ground there. And she's not very careful. I mean, the Vietnam trip, she's got a record of things she was doing that lead to consciousness of guilt. So if you combine that she's so meticulous with the fact that she's not very careful about covering her tracks, I think there's fertile ground there to believe that there might be something, even after all these years, if they didn't look, 8 years ago or 9 years ago, that will create a trail to Wendy. And if so, that's not evidence that they would have used before, because that's evidence they would not want to have been corrupted by the immunity. And that is evidence that they should have been put in that case and put the lock on it with a date on it to show when they had it.
Yeah, good comment. That's what Katie was just mentioning. We don't know when the kids were registered for school.
And
So
most of the
that
schools are over enrolled down there too. So like there's a cutoff, you're done. You cannot get into the school anymore. There's a wait list and you're not starting school there.
And that was true, in 2014, because that's
yeah.
when they moved. So, okay.
Mm-hmm.
Yeah.
Yeah. It's, the population down there has grown exponentially since the 80s. They've never had enough public schools. It's kind of kind of a known factor that you try to enroll your kids as soon as humanly possible.
Yeah. Okay, it was about winning versus losing. Yeah, that too. Are the Adelsons out of money yet? I don't think so, because the stock market has done pretty well in general. So, they had tons and tons of money to start with, plus lots of rental properties, probably at least 40 plus rental units. And they sold Charlie's 2 houses in the last couple of years. Wendy's condo is still being rented out for about $5,000 a month rent for Wendy's condo. I saw that online. So there's money coming in, and I'm sure Harvey's getting, Social Security too, and they had plenty of investments.
Well, and Donna's expenses are being paid for by the citizens of Florida. So
Right, they're saving money, because can you imagine how much she probably spent every month?
on facials and exercise classes and spas and everything. Yeah.
Liposuction, Botox, massages, private trainer, fancy restaurants, travel, clothing, Nordstrom.
Of course, they're now spending it a lot on lawyers and experts and
Commissary.
yeah, commissary for
interesting-
her and her dearest friend in the jail. To keep her from injuring Donna.
The interesting
I
thing
don't want to
about
make
Florida,
light of it. I mean, jail is terrible, and I shouldn't make light of it. But
the Florida real estate market. So Florida has I think the largest number of vacant homes in the country currently. We also have an insurance crisis because we keep getting hit by these hurricanes. And then all the insurance companies have to pay out, and a lot of them have gone bankrupt. So we have state-run insurance now, and it's a whole mess to be a homeowner in Florida, particularly down south, where you are 100% in the crosshairs of every hurricane coming off the coast of Africa. So I question, all these properties have appreciated. My question is whether there's an appetite to be able to sell them.
but they're still getting
Because of
rent
where
from
they
it.
are.
They're not going uninhabited, are they? Do we know?
Yeah, that's my question. I don't know if there's a market to sell if they needed to get quick money. And I also don't know, because rental rates have skyrocketed down there too. So they may be taking in enough just from rent. I just don't think that there's really the market to sell or buy right now.
Yeah, I'm sure they're getting plenty of rent money because of that, that lawsuit where the former property manager sued Harvey for unpaid wages. Yeah, that's where I think is where we found out that there are at least 40, maybe 47 units that are being rented. So I'm assuming they already purchased it.
A month.
Yeah, that's a ton of money, and now he doesn't have to pay for Donna's food and travel and clothes and whatever personal
One-way
upkeep.
tickets.
Yeah.
But he's now got 2 residences, because doesn't he have a rental place in Tallahassee for the trial? And they're paying lawyers right and left.
Yeah.
And experts. So.
And one of the things that you don't ever really think about until you have to pay for it, transcripts and court reporters. That is where a lot of money gets spent.
Yeah. That's right. Quarters from the laundromat and their rental properties. Yeah. I think they've done well investing. So, I don't really feel like they're going to totally go broke. Yeah. So, phone calls and commissary. Okay, great. Well, it's almost 2 hours now. So do you guys want to call it at night? I kind of need to go and eat something and rest my voice and stuff. So Yeah, it's been
Yeah.
great talking to you both, because
Yeah.
every time we talk about this case, time just flies right by, and it's like, oh, it's almost 2 hours, you know?
Well,
Yeah.
I would just like to say again, actually, the one thing I want to say again is, Judy, how well you run your channel and how insightful, how well you know this case, what great questions you ask. And Katie, it's wonderful to get inside baseball knowledge in as many different areas as you know things about, both the Miami, the school system, the real estate market, the prosecutor's office there, all of it. I mean, it's just terrific because, I mean, we're still speculating a lot, but you've provided so much more concrete information on which to understand, or from which to understand the case. So I'm really grateful to you too.
Yeah.
And back at you, you explain things significantly better than I ever could.
Well,
She's had a whole lifetime of teaching.
I know, it's so great to have somebody who is just used to breaking it down for students daily, and to just be able to move through it in a very logical manner.
Yeah, it's great. Okay, maybe just a couple of questions. Why would Harvey not attend today's hearing? Isn't that odd, since he attended past hearings?
I
Maybe
didn't
he's
even know
not
he
in.
wasn't there. I have no idea.
No, mentor lawyer said he wasn't there. He
Okay,
was there
I
in
didn't know.
person. Yeah, so Harvey.
Maybe he has a cold.
Yeah,
Yeah,
could be.
I'd expect he's
Or-
already up here for jury selection.
yeah, yeah,
That's true.
yeah.
Yeah, and talking with the lawyers. Yeah. Let's see. Okay, last question, off topic. Isn't David Oscar Marcus's representation of, is it called Ghislaine Maxwell, career suicide, seeking a pardon for a pedo? How do you feel, Katie? You're a defense attorney.
Look, everybody deserves a good defense lawyer. I don't think representing any single person is career suicide for a defense attorney, just because of the nature of the job. I will tell you that it was a circus up here when they did their very short notice, interview of her. And I have a client in the federal detention center, and I came in a couple days after they did that, and she had not been moved at that point to I think someplace in Texas now. But I was asking the guards, like, by the way, if this ever happens again, I should try to not be here for that, right? And they said, yeah, we locked everyone down. They had to pull out all these extra guards. There was zero notice. They were calling other people in. And I was like, all right. So it was just an absolute mess. And they apparently brought her over to the federal courthouse, but they still had to bring, guards with her. So the facility was not appropriately staffed, is the way that I heard it. So I'm glad she's gone. I'm glad she's gone from the place where my guy's being kept, so it's not my problem anymore. But I don't really think that you can commit career suicide as a defense attorney. I mean, if you're a criminal defense attorney, you represent people who are, can be loathsome to the rest of society, and your job is to protect the rest of us by supporting the Constitution and making sure everyone follows the rules. And because the rules don't change just because you're representing somebody who is a loathsome human being and really gross. It just doesn't. The same rules apply to everyone. So,
And if they didn't apply to everyone, they might not apply to everyone. I mean,
Right.
if you're not willing, I mean, I do think providing lawyers and doing what defense lawyers do, and not just defense lawyers, but, the whole gamut, speaks how jail should be run, speaks more to how we want to operate and how we want to act as, as members of this society, than it does to the person who's in the jail or the person being represented, because I believe this firmly, and I know it sounds like Pollyanna, but I think it diminishes us when we don't do a good job for those who are, for whom you can't say anything sympathetic, or nice or anything else. And I honor defense lawyers because I think it has to be extraordinarily difficult to represent somebody like Stefan Stearns. I mean, I just think that's a representation that had to extraordinarily difficult. But we would be diminished as a society if there weren't lawyers there who were, out there willing to hold the state to its, to its proofs and make sure that it's operating properly for everyone, to you and the whole defense lawyer profession.
Yeah,
And also to prosecutors who I really like when they're doing their job.
But there's also the fact that, like, if you feel like, even if you're a public defender and you feel like you cannot defend this person to the fullest extent that you are permitted to do so by law, you should be asking to get off the case or to swap cases with somebody else. And I have refused to take cases in the past, specifically animal abuse cases. I just cannot stomach most of them. It's just something I can't do. So interestingly enough, sex case is fine, animal abuse not. But for whatever reason, that's my line. And there'll be other people that won't take child sex cases because they just can't. And if you know that about yourself, kudos.
Yeah.
Someone is asking us to do this every Friday. Well, maybe not every Friday, but once a month or so. It'd be great for us to get together and talk seriously about whatever case or stuff is in the news. That would be wonderful if you have time. That's a question. So, yeah. And all your talk about selecting a jury, you're making me freak out because I have a jury trial coming up in 2 weeks. And I'm like, oh my God, I really need to get off YouTube, but it's so addictive. Like you watch a show, then you want to comment, and then you want to watch another live stream and check the comments. And then I have to take care of my comments. And,
and then the comments are where it's at.
Yeah.
Yeah.
But you do a great job, so don't stop.
Okay. Yeah, I'll try. But that week of the 25th, I think.
And if anybody in this chat has not seen some of Judy's comedy shows, they are classic.
Yes.
The last one you did, I thought was just wonderful. Well, that's all I can say. Wonderful. So creative.
And the attention to detail. The outfits.
And the observation. I mean, you have to observe in order then to attend to it. Just wonderful. Judy's acting talent is just great. And hey, Mona has the best deadpan presentation I have heard in my life. And the two of them together are just really hilarious.
Yeah, I'm so glad.
Really, really serious stuff, but it's nice to be able to lighten up about it. So
yeah, and it's also educational too, because sometimes Mona would make jokes and I'm like, huh, was that some detail that I missed? Or I'll go back and rewatch it and catch all these like little jokes that Mona said that I didn't understand while we were doing it live. Because when we're doing it live, I'm constantly thinking like, what am I going to say next? Or how do I make this funny? Or, what do I say? It's very much.
It doesn't show. It doesn't show. And Patty Ann, I just saw in the chat, said, and you're an ice skater too. And you did a show on ice skating. I watched it.
To the Wendy song.
To skate, figure skating. That's my skating channel. Thank you so much. Yeah, I'm actually, you guys will think I'm kind of crazy, but I'm planning to compete at adult national figure skating championships again next year. It's going to be in Atlanta. So I was the pewter medalist back in 2006 in Dallas in my category.
Wow. Yeah. Do you have another trophy like your Oscar that you were given?
Yeah, they give medals at these skating competitions. So I have a ton, but it's because not many adults skate. So there's not a lot of competition. But my new program is to The Way We Were, and it's dedicated to this case because, that's the song I kept singing. The one that goes, memories like the corners of my mind. Yeah. So
misty watercolored
memories. How do you know that song?
Of the way I have parents.
That's from a show, isn't it? What
The Way We Were is a movie.
The Way We Were, the movie, yeah.
1974, Barbara Streisand. Scattered.
And I believe I saw that on TV a while ago, and Robert Redford, isn't it? Isn't Redford the Yeah.
Oh, thank you so much, Patty. Patty's the person who used to work for Harvey Adelson back
Ah.
in
That's that Patty.
1986-ish. Yeah. So Patty was also the butt of some of our jokes because, we were making fun of how Patty, she was upset on my live stream interview, recalling how Donna just sent Charlie and Wendy to her wedding with no notice. And Patty's wedding was on a cruise. She was concerned about finances, and she had already told her friends they couldn't bring kids because of the
Right.
finances. But yet here comes Harvey with Charlotte, the office manager, and Wendy and Charlie. So, and then Harvey volunteered to do the video camera work, but then he zeroed in on Charlie and Wendy during the vows. So anyway, that was great comedic fodder, though. So thank you, Patty, for that comedy bit. Yeah, thank you.
And anybody that's ever planned a wedding knows that is a line you do not cross.
I'm sort of running through the chat right now, and I think this is a great little quote. And it also sums up some of what we were talking about at the end from Walk Away Renee. John Adams defended the British soldiers and actually won the case. And that was, the one of the last episodes before we ended up, in the Revolutionary War. So that's great.
Okay. Oh, here's one more serious question. Yeah, whatever happened with that motion regarding Rob Adelson? Did it get ruled on?
There was nothing said about it today.
Maybe that was in
secret
camera.
Yeah, it's just
It's hard to believe that would be the one that would be, although you may be right. I mean, but it wasn't mentioned today.
Yeah.
So it may have been ruled on, they may have agreed on it before. I don't think the defense would have withdrawn the motion, but the state and the defense may have agreed as to the scope of the evidence that can be raised by the state when Robert Adelson's on the stand. I mean, the thing with these trials is that some of the things that happen behind the scenes, we just never know. Some of it we'll find out at trial and we may be able to guess, and some of it not.
Or we'll find out much later in the appellate documents.
Right.
Mm-hmm. Well, I kind of think that the state knows better than to ask Rob, do you think your mom did this? I mean, it's just kind of common sense, some of the concerns that Donna's attorneys had in that motion, and the thing about some racial slur. I don't know if they're saying that Donna said a racial slur and then Rob talked about it. I mean, they're not planning on bringing that stuff up anyway.
Yeah, well, they can't. The racial slur, as I recall the motions, was something that the state wanted to keep out. So it seems to have come from one of the state's witnesses. It's hard to tell what, I think that's the way it read. It wasn't coming from anybody the defense would have used. So we don't know. We don't know what it was, but yeah, the appeal, a lot of it shows up in the appeal briefs, and you're right.
Yeah, eventually we'll find out. My Hotel California, my sweet spot is going to be the 3850 motion on Charlie. I'm going to take some time off for that one.
All right, then you have to go on Judy's show and report everything.
Oh, I'll be with my giant ear things.
Yeah. Well, I'm speaking for Judy now. She'll give you a 4-part, to get through it all.
But it's going to be amazing. I keep thinking through it, how much fun it's going to be to just watch. Exactly. Because you're going to get, it's basically an airing of the grievances against your defense attorney. And it's going to be amazing.
Yeah. Yeah. Well, I think it's Hey Mona who is wanting us to report every single day of the trial. There's no way, because that week of even the week that jury selection starts, I think I'm going to be really busy preparing for my own trial. And then it starts on the 25th. So, I mean, yeah, I need to get some work done. But what about you, Joe? Have they already enlisted you to be a special guest every day on Surviving?
I'll do the commentary like I did today at the hearing. I won't be able to do the voir dire, although I am, I think, one of the few people in the world who actually finds voir dire interesting. I love to watch voir dire, but it's Broadway, Kids on Broadway week, and I'm taking my niece in to see a show on Tuesday night, and then we're going to do Wednesday matinee and Wednesday night. And so Tuesday, Wednesday, Thursday until 5 o'clock, I'm going to be doing family things and, New York things. And I'll be curious, but.
And the early jury selection in a case like this is just so slow.
I know. I still
one
love
at a
it.
time, and
I still love it. Same questions, same answers, but I still just enjoy it.
yeah.
But you're right. It's not the heart of the trial, clearly.
Oh, I like it in front of the whole panel when you get to do the group interaction and you're having to control a conversation between people and trying to have them play off each other. That's how you know somebody's really good at it.
Mm-hmm.
Mm-hmm. Well, Katie, are you going to actually be in the courtroom during parts of the trial?
I don't think so, because I find the acoustics in the courtroom to be really difficult. For whatever reason, they didn't have audio engineers go through these courtrooms. There's dead zones. You can hear it significantly, hear and see so much better with the streaming thing. Plus then I can eat chips and stuff.
And there are going to be fewer seats available because
True.
Donna's side is getting, what did the judge say, 2 rows for family and friends. And,
that might be worth it to see who shows up.
And then
though.
the Markels will have some seats. So that's 2 fewer rows than they had for Charlie's trial, because there were no family and friends there for Charlie.
Mm-hmm.
Yeah.
It's interesting to me, the difference.
Okay.
Yeah.
I'm sorry, looking through the questions before we say goodbye. Joe, you're from New Jersey, aren't you?
Yes, but it's the New York metropolitan area. I'm 30 minutes outside the city.
So pretty much New Yorker-ish.
Well, the sort of the attitude and the, take no prisoners, and yeah, we in this part of New Jersey share all that, for good or ill. It describes us too.
Yeah, okay. And the person that wanted to know about my skating competition, yeah, they do, I think they live stream it now. It's very technologically advanced now. The U.S. Figure Skating Association has a YouTube channel where they even, will live stream the adult national championships, and they keep it up on their website. And if I do well, I'll probably put a video of it up on my figure skating channel, the Live to Skate figure skating.
You need to bronze one of the skates. The way they used to do baby shoes way back.
Yeah.
Whenever. Yeah.
Yeah, luckily I was finally able to find someone who wanted to buy my beat up old ice skates, so I don't have them anymore. But yeah, it's hard to get rid of them. So, okay, well, I gotta get going because I've run out of water. Well, running out of water and stuff. So thank you guys both so much for your time, and we'll definitely be in touch. Even if we can't do this every week or something, maybe definitely during a trial. At least once would be great to get together with you two again. So
Okay.
Happy to do it.
Yeah,
Okay.
Thanks a lot.
Joe.
Thanks to the questions and comments in the chat. I'm reading them here as
okay,
I go.
Joe, are you near Edison and Linden?
Not too far. Not too far.
I think she wants to protect her privacy. We can't be telling everybody where we live, right? You don't know who's watching us. Some stalker type.
I doubt I'm interesting enough to get a stalker, so don't worry about it.
Well, Katie, I hope to meet you in Tallahassee. I just bought my plane ticket today.
Ooh.
After the hearing, I was like, woohoo, it's time to get on delta.com. I'm buying my ticket. So, but I'm not going to say exactly when I'm going. I'll contact you directly because
text me.
once again, I'm worried about crazy people. So sorry.
Yeah. Feel free to come sit in the office and watch, or sit in the courtroom.
Yeah, I'll probably go to the
grab lunch.
courtroom. Yeah. Okay. Well, thank you guys. Have a good evening and have a great weekend, everybody. Justice for Dan, of course.
Long, Judy.
Thank you.
So long, everybody.
Yeah,
Bye.
I won't be there the whole time, but just a little part of it. So, okay. Have a good evening.
Bye.
Bye guys.
Bye.
Thank you.